Good morning, everyone. My name is Jana Shrihita from third year Computer Science Department, Sri Sairam College of Engineering, Bangalore. So, without any further delay, let's go directly into the topic of patents. So, in this whole presentation, I'll be explaining about only patents, what is a patent, or what are the rights which are being granted for a patent, or what is the whole process of patent. We would have heard in various places about patent. So let's get to know what is a patent. A patent is an exclusive right which is being granted for an innovation that generally provides a new way of doing something or offers a new technical solution to a problem, which means finding a solution to a problem, and this solution which is being found is completely new from the already existing ones, and the rights which are being granted to it are known as patent. The exclusive right legally protects the invention from being copied or reproduced by others, which means if law says that a patent is being given to this particular invention, no other person is allowed to copy or reproduce the same innovation. Conditions for obtaining a patent protection. As provided in Section 2 of Patent Act 1970, there are few criterion which has to be followed for a product or a process to qualify for the grant of patent. The first one is the novelty, not part of state of the art, which means this particular innovation which was being claimed must not be similar or exactly same ones must not be already existing in the whole world. In other words, the innovation is not in the knowledge of public, not published anywhere through any means of publication, and not be claimed in any other specification by any other applicant, which means it must not be known to any public or it must not be published anywhere. It can be either in journal, papers, magazines, etc., or must not be given or claimed by any other applicant. Inventive step. Not obvious to the person skilled in the art, the innovation is a technical advancement over an existing knowledge. It possesses economic significance. Capable of industrial application, this includes for the societal benefit. Facts on patent. The record for being the youngest patent holder was given to Master Vaishalini NC of Tamil Nadu. She invented an automatic multifunctional life rescue flood house system at the age of 6 years. Now, what all inventions are eligible for patenting? Patents may be granted for inventions ranging from paperclip or ballpoint pen to nanotechnology chip or till Harvard mouse. Let's take, for example, a penicillin. It was an antibiotic or is an antibiotic which was mainly used to kill microbes and its derivatives. So let's say penicillin 1 was used to kill few microbes and has few properties. As years passed on, there were new derivatives which have been derived from the same penicillin. So therefore, these derivatives also, the second, third, fourth generation penicillin also can be given patent. Or our daily life objects which may include toothbrush, toothpaste, shoes, pen, eyeglasses, textiles, mobile phones, wristwatches, bicycles, scooter, car, television, etc. will also be given patent. Or uncommon objects which may include cars, mobile phones, televisions, laptop, computers, etc. Now let us know what are the non-patentable matters. Invention contrary to public morality. Anything, any invention which goes against the morality of human beings, which may include human cloning, gambling, drug dealing, etc. Mere discovery, which may include new microorganisms, laws of gravity, or any new laws may come under mere discovery and will not be given patent. Mere discovery of a new form of a known substance. Let's say, for example, aspirin. Aspirin initially was used to treat fever. Later, it was found that aspirin was also found to treat cancer. Arrangement or rearrangement. Example, umbrella, fan, etc. Let's say fan, new inventions such as table fan or hand fan will not be given patent. Inventions falling within Section 20 of the Atomic Energy Act 1962, elements such as uranium, beryllium, thorium, plutonium, etc., will not be given patent. Literary, dramatic, musical, artistic works, writing of books, sculptures, drawings, paintings, computer programs, mathematical calculations will not be given patents. Or topography or integrated circuits, plants and animals, traditional knowledge, all these won't be granted any patent. To patent or not to patent an invention. An inventor has a complete right to decide whether to keep his invention for his personal benefits or to give it for the public domain. If he wants to give it for the public domain, for commercial or societal benefit, it can be either done with paying or without paying any money to the inventor. If he wants to seek for any monetary gains, it can be either done by two options, patenting or trade secret. Trade secret may be when he or she wants to keep secrecy of invention for a very long period, let's say 100 years, then he can go for trade secret. Or if he prefers for a shorter period of time, which may be around 20-30 years, then he can go for patent. Rights associated with patent. As per court of law, a patent owner has the right to decide who might use and who might not use the patent invention. The invention cannot be commercially made, used, distributed, imported, or sold by others without the consent of the owner. If the owner agrees to make use of a particular patent, then until and unless it is mutually agreed by both of them, then only it can be used. The patent holder has a right to sue the party making use of illegal use of a particular patent. Enforcement of patent rights. Enforcement is a process of ensuring compliance with laws, regulations, rules, standards, and social norms. And this is being taken care by the judicial law. Even though the punishment is being given by the judicial law, the monitoring, identifying, and taking action must be done by the patent owner itself. Patent infringements. Let's take, for example, I have patent for a particular invention and I'm not giving any right to others for making use of my particular work or a particular invention. But he is using it without my consent. This will come under patent infringements. They are classified into two categories, direct infringements, indirect infringements. Direct infringements, when a product is substantially close to any patented product, or in a case where the marketing or commercial use of an invention is carried out without the permission of the owner of the invention. If it is an indirect infringement, which means accidentally he is making use of the patent. No matter whether it is a direct infringement or indirect infringement, still people making use of a particular invention without the consent of the owner are still being punished. Avoid public disclosure of an invention before patenting. An invention that has already been either published or publicly displayed cannot be taken for patenting. And Patents Acts provide a grace period of 12 months for filing an application. If a particular inventor finds a potential investor or a business partner who would like to invest in his invention, then a non-disclosure agreement is being signed between both the parties, saying that they are not allowed to disclose it to the public, and therefore is done. Let's go to the last topic, that is the process of patenting. In the right side, we can see a flow chart which mainly describes how the process of patenting occurs. In India, process of patenting is a very lengthy process and it takes around 3 to 4 years or more. The major steps involved in this are filing of application with IPO, publishing, examination, and finally grant of patent. While in previously, as told, it is a lengthy process. There are intermediate steps which has to be taken care, which may include prior art search, choice of application to be filed, patent application forms, jurisdiction of filing patent application, publication, pre-grant opposition, examination, grant of patent, validity of patent protection, post-grant opposition. Let's learn about each and every topic one by one now. Prior art search. We cannot just invent a new object and ask for patent, because first we need to check whether the object or the particular invention is already existing, or any other similar inventions are already existing or not. So this process is known as prior art search. For this, he or she needs to read patent documents and non-patent literature, scientific journals, reports, magazines, etc. So this can be either done before filing of patent application or the priority date of patent application. And this whole process is known as prior art. There are two categories under which you can search. The first thing is the patent databases. The patent databases include Indian Patent Advanced Search System, Patent Scope, eSpaceNet, USPTO, Google Patents Advanced Search, Orbit Intelligence, Derwent Innovations. The links given here are the links for these websites for the patent databases. The next one is the non-patent literature. Scholarly publications, which may include handbooks, textbooks, patents, encyclopedias, journals, etc. Industry or trade publications, industry reviews, and public disclosures, which can be either done in social medias, YouTube, books, magazines, etc. Others, which may include newspapers, websites, research papers, etc. There are few paid journals. In those also, research must be done. So this is the whole process of prior art search. The next process is choice of application to be filled. There are two different types of applications which are normally filled: provisional patent application or complete patent application. What is provisional patent application? It is an application which can be filled within a particular patent if he finds a particular patent is not been invented till now, and if he doesn't, or if he did not complete his experimental process also, he can do this or fill this provisional patent application, and a priority date must be fixed for it. Whereas in complete patent application, full application will be filled after the examination or the whole process completes. So mostly the provisional patent application itself will be done because it is more cheaper, it takes less time and involves fewer formalities. And the major advantage of this is it does not require complete specification, which means even though there are pending experiments, you can fill the form, and it allows you to secure a priority date. Patent application forms, as per Patent Act 1970 and Patents Rule 2003, there are two forms to be filled. Form 1 includes general details, which can be title of application, names of applicants and inventors, type of application, etc. Whereas Form 2 includes if it is a provisional application or whether it is a complete application. If it is a provisional application, it includes description of the invention and abstract itself. Whereas if it is a complete application, it includes description, abstract, claims, and manner in which the invention have to be performed. The claims of the patent plays a very important role because it defines the actual boundary of the invention, and these claims are being protected. In the given slide, there are two different forms. Towards the right is the Form 1, which asks for the basic information, which includes applicant name, nationality, address, etc. Whereas in Form 2, it asks for the title of the invention, applicant details, as well as description or abstract, or whether it is a provisional or a complete application. The next one is the jurisdiction of filing application. Now our application is being ready. Now where should I post this application? Under which jurisdiction will I come under? So if my state is is in North India, which may include Haryana, Himachal Pradesh, Punjab, Rajasthan, etc., then the address is Intellectual Property Office Building in Dwaraka, and the details are being given here. Whereas if it is at South India, like Andhra Pradesh, Karnataka, Kerala, it will come under Chennai. If it is West, then Maharashtra, Gujarat, Madhya Pradesh, Goa, etc. In Mumbai, whether all other parts of India, whereas rest of India, then it comes under Kolkata. Now, publication has been done. For this publication, the patent application is being kept secret for 18 months, which means no other person, it can be people in patent office also, they are not allowed to touch this patent application for 18 months, or it must not be disclosed to the public for 18 months. And later, after the expiry of 18 months, it is being published in the official journal of the patent office. The main purpose of publishing the application is to inform the public about the invention. Now comes the pre-grant opposition. If anybody has an objection about the invention, then he can challenge the applicant, and this can be done within 6 months from the date of application. Now, depending about on the outcome of the case, it will be decided whether to reject or to recommend for the next step, that is for the examination. Now, within this 18 months, the patentee has a special right to sell or give license for his particular patent, and this can be done under Form 9. Next step is the examination step. The patent examination is a critical step, and it is being done under the professionals. The professionals or the examiner raises certain questions or doubts to a particular patentee, and then this patentee is allowed to answer for the received, and these answers are being received from the inventors. And based on these answers, it is decided by the professionals whether to accept it and give a patent or not accept it. The applicant or his representative has a right to make a request for the examination of patent by filling Form 18A and submitting the same within 48 months. Grant of patent. Finally, after the examination step, the patent is being granted to the applicant. And this is being published in the official journal of Patent Office. And the journal is being published every Friday. Next comes the validity of patent protection. The applicant for the limited period, generally for 20 years it is being done, and must be renewed annually as per Section 53 Rule 80 Indian Patents Act. If non-payment of patent is being done, then the cancellation of patent is done. In some countries, extension of this particular patent can be done beyond 20 years. Let's say a particular patent has taken more amount of time for the administrative approval procedure, then the time can be extended. Post-grant opposition. Once the patent is being granted by the patent office, it still can be challenged by anyone within 1 year by the public. And either this can be done by from the patent office or in the court of law. And there are few challenges, or they invoke a patent upon a successful challenge by the interested party on the grounds mentioned below. The applicant for the patent wrongfully obtained the invention or any part of the invention. The invention claimed has been published before the priority date. The invention claimed was publicly known or used before the priority date. The invention claimed is obvious and does not involve an inventive step. The subject of the claim is not patentable as per Chapter 2 of Patent Act 1970. The details or specifications of the invention do not sufficiently or clearly describe the invention. So, this is the post grant opposition. This is the end of the process of patenting. So, till now, we have learned what is patenting, what are the inventions which come under patenting, which will not come under the patenting, or enforcement acts which come under patenting, and the whole process for patenting. Thank you.